name is Moses Morok. I'm from Wezi Consultants Limited. Wezi Consultants is a legal technology company which seeks to bridge the gap between legal services and access to justice by integrating technology and enabling individuals, businesses, those in the legal fraternity to utilize technology in providing legal services and accessing legal services. So our inaugural product is the Legal AI platform, which allows you to access, it's a self-service platform that is AI powered. So you can, register your business on it. You can produce, contracts using AI, using it. You can get your questions to Ugandan Law questions answered on the platform. And the other thing we're doing is we're also doing legal technology education to inform the public how they can utilize artificial intelligence and other emerging technologies to access legal services. All right, today on the Law podcast, we are going to be learning about the law relating to work, or you could call it employment law. So we will be learning what your rights are as a worker, what your obligations are as a worker, what your rights are as an employer, and also your obligations as an employer, and also if you sit on the government side, just to understand your role in all of this, and those also in the private sector, say the NGO sector, who are helping preserve fundamental rights relating to work. I think this will be a very good discussion for us today. So minimum, as the word states, just means like what is the starting point. So in relation to salaries, this refers to, or we can refer to them as wages alternatively. That means what is the least that someone can be paid. That's the definition of a minimum wage. The issue of minimum wage has been contentious. On the one hand, we actually do have a law that speaks about what the minimum wage is, but unfortunately it's a very old law. So it's a law from the 1980s that sets the minimum wage at about 130,000 Uganda shillings. But we've seen, unfortunately, our economy or our wages have been left to to demand and supply really. So the law has not been enforced. So you even find people earning like 100K, a month, which is below the minimum wage. So ideally, when you speak of minimum wage, it should be that you shouldn't go below this. We already defined it to be like the minimum. So if you go below it, then it becomes illegal. So minimum would be like from that point going upwards. So the strange thing is we have a law, but it's not being enforced. And so because we have an imbalance in the sense that there is more demand for work than there is supply of work, we then have a situation where it seems like it's been left to the market forces. And now, because employers tend to have the upper hand, they tend to pay whatever they want to pay. But the conversation has been ongoing in Parliament and elsewhere and other spaces. A contract is basically an agreement between two or more people. So where one person makes an offer, so you say, this is what I'm going to pay you in exchange for this. So there's an offer and acceptance. When the two people reach an agreement, what we refer to as the meeting of the minds, then the contract becomes effective. Of course, there are other little things that we need to know, but we won't get into them today. Things like you must be of age to contract. For example, if we're speaking about work, you can't, we can't have an 8-year-old contracting to work. That's illegal because the law doesn't allow that. Those that are maybe, below 16 and below can only work, but, minimally, yeah? So There's some, work that is not heavy, and it should not be full-time. You could do it just like as part-time as you study. So yeah, so we must be mindful of that as in the context of workers' rights and employment law. Types of contracts differ. It depends on what what area of life we're speaking of. But in the context of employment law, we have two types of contracts. We have what we refer to as a contract of service, then a contract for services. So a contract of service is where we have someone coming to work for you, but she's not your employee. Sorry, a contract for services. Let me just contract for services where someone is coming to work for you, but is not your employee. So it's like how you can call a plumber to come to your house to fix something. They come for that moment, they come with their tools, fix something. And so they're not your employee, they come do the job and you pay them and that's it. Then a contract of service is where now someone works under the control of another for a longer period of time, and so that's what we refer to as naturally employment contracts. So labor law really refers to the latter contracts. What I mean here is contracts of service, where you're working under someone and you're referred to as an employee and there's an employer. So just also important to note that this labor law does not cover, so it's split into two. There is that for the private sector, then that for the public servants. So public servants have their special law. So there's something called the Public Service Commission and the Public Service Standing Orders. Those are their laws. Then for us here in the private sector, we have the Employment Act. That's like the main law, yeah? So the army would then be an example of public service, work. So it wouldn't be covered by the Employment Act. But ideally, I'll speak to both scenarios. In the private sector, so if you get injuries, there's a law called the Workers' Compensation Act. It's a law that covers the compensations, or you may call it maybe reparations. Okay, reparations would be the right word, but compensations for injuries. And the injuries are, defined. There are those injuries that are referred to as permanent injuries. So they refer to them as permanent. Then there are those that are not permanent. Then there are those that are permanent but of a partial nature. Then there are those that are total but not permanent. I know it sounds very confusing, so I'm going to give an example. So for example, if I go blind, that is, and it's total blindness, like never going to recover my sight. That is a permanent injury, and it's total in the sense that it's both. If it's both my eyes, that's total. But if it's just one eye, it's a partial permanent injury. Is it making sense? So it will be partial because I still have one eye, but it's permanent in the sense that my one eye which got damaged will never be recovered. Making sense? Okay, so the way that compensation happens depends on what kind of injury you've gotten. So I know you're referring to maybe also psychological or sometimes physical. So all of that is weighed, and the courts have come up with a method of calculating. So, for example, what is your age? All of that, how much are you earning? Those all become factors in computing the award, the compensation, and is provided for under that very law. So I must mention at this point that the Ministry of Government that's responsible for workers is the Ministry of Gender, Labour and Social Development. I think Betty Among, she's the minister. And there is a law referred to as the recruitment. There's a labor recruitment of, it's recruitment agencies regulations. There are regulations for recruitment agencies because these people that go abroad to work, they are recruited by an agency and sent abroad. So there are regulations covering how those agencies should manage the rights of these employees. One, for example, they're supposed to have an office in the host country. So like if you're sending people to Saudi Arabia, then you need to have a host office there where these employees can come and make complaints. You understand, eh? So therefore, however, you must understand that the contract of employment then is being signed with an international client. In this case, it could be, say, a Saudi Arabian, client taking on a Ugandan employee. And it's important that when you're signing that contract, you could negotiate some things and say what law will apply to our relationship. If you say it's Ugandan law, then all the rights that the worker enjoys under Ugandan law would apply. Unfortunately, if you go there and sign a contract and they mention that it will be Saudi Arabian law that will apply, then the courts of Uganda cannot intervene. However, again, we need to take note that the international conventions around the labor market, so we have an organization called the International Labour Organization, which has conventions, and we have also conventions like the ICCPR, which is the International Convention on Civil Political Rights, the International Convention on Social and Economic Rights. That's the one that particularly would apply to this situation. It's a convention that speaks about how workers should be treated. So you have things like, things like slavery are banned. So those conventions would not allow slavish conditions for the workers. So if it fails, if you find you in a situation where Ugandan law doesn't apply, you can now go to international tribunals under the International Labour Organization conventions. So there's both what we refer to as international law, and what we refer to as municipal law is the local law or national laws. So it just all depends on how you contract. So I advise those who are going abroad to make sure, if you can, insert in your contract that Ugandan law shall apply. That way, you're conversant with the law. You can get a lawyer here who can advise you, because if it's Saudi law, you would probably have to get a lawyer the other side. We talked about contracts of service. Also within contracts of service are also mini contracts. We refer to there's a type of contract called a probationary contract. Then there's of course the permanent employment contract. So a probationary contract is a contract where the employer is hiring you but wants to see how competent you are. So they may try you out for 3 months, then an additional 3 months. They can't go beyond 6 months trying you out. Even you as an employee, you may want to see if this is an organization you'd like to work for. You could change your mind at some point. So in such a context, under a probationary contract, back to notice periods, there is no need to issue a notice. Either party can terminate the contract immediately. However, if you now change over from a probationary contract to a permanent contract, then now the law comes into play. So it comes down to how long you've worked. The longer you've worked for an organization, the more the notice period should be. So if you've worked for a period of less than 6 months, no notice. Oh no, sorry, a minimum of 2 weeks. If 6 months to a year, 2 weeks notice. Beyond a year, a month notice. Beyond 5 years, 2 months. Beyond 10 years, 3 months. So it all depends. So Thing is, if you don't want to give a notice, the alternative is something we refer to as a payment in lieu of notice. A payment in lieu of notice is just a Latin phrase to, in lieu, that's still an English word, but borrowed from Latin, I believe. Someone will correct me, a linguist. But yes, it means that you say, okay, my notice period should have been a month. But what I'm going to do is I'm going to get the equivalent of my salary and benefits for that month and pay you, so I pay myself out. So that's actually a convenient situation where there's a breakdown in the relationship. You guys can't see eye to eye, you just don't want to be in the same space. So that's an alternative, both for the employer can do the same for you, can say, you know what, I don't want to see you again, I'm going to pay you a 3 months notice. And they pay you, and all right, so non-competes, or also called restriction of trade clauses. They're very common in employment agreements. The way that they work is to protect the employer, the employers, say like trade secrets, for this employee not to go and share. Because some people can, the business world is quite competitive. They could, come in as employees, but they're basically doing market research, really, come in, so, and then exit and then share. So it becomes important in that, in that context. However, they are carefully considered by the courts. One of the ways to ensure that it's enforceable is that, one, it should not be wide in terms of geography. So there's a famous case where someone was working in Mombasa and his employer said, you can't work in the same factory within East Africa. That was considered too broad, because that's basically now denying someone the right to life, the right to economic, to employment. So all of these are weighed against the fundamental rights of individuals. So geographical scope, duration also matters. So one that goes beyond like 3 years is normally frowned upon. So it shouldn't be for too long a period. All right, so yes, they're different, because in a non-disclosure, you're referring just to information, like the sharing of vital information that one has learned by working or by relating with a particular person. So it doesn't really refer to working with another individual. So you could actually have a non-disclosure agreement signed with someone, and then you still work with a competitor, so long as you don't share the secrets. So sometimes, of course, you can combine all of that into one agreement. But yeah, non-disclosure agreements are used in different contexts, even with contracts for services. The other one where you have someone coming in and doing work for a short period and going away. Maybe I should first start by looking at the law that protects our fundamental rights. That's Chapter 4 of the Constitution. I think now you understand why that organization is called Chapter 4. But yes, so Chapter 4 includes things like the right to liberty, the right to property, the right to work, the right to a family, the right to be given a fair trial, Article 23 of the Constitution. So all those are fundamental rights, and they're provided at the national level, but also at the international level. So in the international level, we have all of these spinning off from the UN, the UN Charter, then the ones that I talked about fundamentally, no pun intended, the International Convention on Civil Political Rights, International Convention on Social, Economic Rights, the International Convention on the Rights of, it's called the CIHAD, Rights of Women. There's a Convention on the Rights of Women, Convention on the Rights of Children. But here now, this is really, we'll look at all of those, and then also both at the regional level. The African Union also has its own conventions, which also protect, workers, women. So having said that, when it comes to redress then, at the national level, of course, depending on the kind of violation, you would then have the right to go to like the High Court and enforce your rights. There's in fact a law called the Judicature Enforcement of Fundamental Human Rights. It's an instrument. I'm just trying here. SI. It's an instrument just for enforcement of your rights. So you can go to the High Court. The High Court will protect your rights. If that fails, you can go to the East African Court of Justice. If that fails, you can go to the African Court, which sits in Arusha. If that fails, you can go to the International Criminal Court, for example. That's one of the other forums that you can go to. I think more or less, those will be like the courts that you can go to and enforce your rights. This will come from me, like, being in the employment, being an employer, and also having been an employee. I think, the contracts are important, but I think the hearts of the people are what are really, really important in this relationship. Like, the contract is a starting point, but if you don't come with goodwill, I don't think this is going to work out. And because employers should realize that employees are very, very important people. They're actually the important, people. People are like the most important thing, that they're the ones who make an organization run. In the same way that employees should also realize that, and this is for us as Ugandans, I know we may have an international audience, but for the Ugandans, I may say, it's good for us to give our best at work. This is someone is paying bills. There's power, water. So give your best at work, do your part of the bargain, and let's work in harmony. But always have a contract. The unfortunate thing though is that sometimes the law can be it's a lot to read. It may not be too complicated, but there's just too much to read, because you see Occupational Health and Safety Act, Workers' Compensation Act, Labor Arbitrations Act, all of those things, there are too many. So I think now with like artificial intelligence, you can use different tools, Meta AI, Gemini, Copilot, or even ours, Legal AI. You could use it and ask it some questions, but mind you that doesn't replace a lawyer. It may not be 100% accurate, but can be a starting point so that you know your laws. So I believe artificial intelligence is a game changer in that regard.